I have clerked in the High Court of Eldermore for 11 years, and in all that time I never once saw Justice Harlan Voss lose control of his own courtroom. He owned it the way a man owns a coat he has worn so long it has taken the shape of his shoulders. He knew where every draft came from. He knew which of the great doors stuck in wet weather and which of the benches creaked. When he lifted a single gray eyebrow, 40 people adjusted their posture without knowing why. So when I tell you that on the morning of the 9th of the cold month, a common soldier in a red tunic took that courtroom away from him, took it gently, without raising his voice, and gave it back only when he had finished with it, you should understand that I am not telling you a soldier's tale. I am telling you the day I stopped believing that a man's worth could be read off his uniform. My name does not matter to this account. I keep the record. I do not appear in it. But I was seated at the clerk's desk below the bench, close enough to hear Justice Voss breathe, and I saw everything from the first word to the last. What follows is what I saw. The matter that morning was small. That is the part everyone forgets. It was not a murder or a great fraud or a question that would trouble the king. It was a dispute over a strip of pasture, a boundary case, the kind that clogs the lower lists and puts junior barristers to sleep, brought up on appeal because a wealthy man named Corwin Deverell did not like losing to a widow. Deverell owned half the mills on the Aldermere and a great many of the people who worked them. He had lost below, in the country court, and he had money enough to lose again in a grander room with grander wigs, on the theory that grandeur would eventually rule in his favor. He sat in the front of the gallery in a coat that cost more than I earn in a season, and he looked at the widow's side of the room, the way a man looks at a puddle he intends to step over. The widow was called Mistress Ansley. She had no counsel that morning that I could see. Her barrister had sent word he was ill, and she had come anyway rather than lose her turn on the list. She sat very straight with her hands folded, an old woman who had plainly decided that if she was going to be robbed she would at least be robbed with her chin up. Beside her, standing, not sitting, was the soldier. I did not know his name yet. None of us did. He wore the full ceremonial dress of the king's guard, the deep red wool tunic with its double row of brass buttons, the white belt, the white gloves tucked under his arm because a man does not wear gloves indoors, the row of metal ribbons over his heart, and the tall black bearskin that he had removed and held in the crook of his elbow with the exactness of a man who has done it 10,000 times. His boots were mirrors. His collar was a straight line. He stood behind Mistress Ansley's chair, the way a fence post stands, as if he had been driven into the floor of the world and had no intention of coming out. Justice Voss saw him, and something in the old judge's face curdled. "Clerk," he said to me, without looking at me, "why is there a palace ornament standing in my courtroom?" I began to answer that I did not know, but the soldier answered first, and that was the first surprise of the day, because ornaments do not speak. "I am here at the lady's request, my lord," he said. His voice was low and even and carried to the back wall without seeming to try. "She is my aunt. Her counsel is unwell. I came so that she would not sit alone." "Her nephew," said Voss, and let the word hang in the air a moment to cool. "How touching! And I suppose you intend to stand there in your parade costume and glare the appeal into submission." "I intend to stand quietly, my lord, unless the court has need of me." "The court," said Voss, "has need of you to sit down and be silent, which I understand is the one thing your regiment is trained to do." There was a ripple of laughter from the gallery. Deverell's side led it. I have heard that laughter many times since, the laughter of comfortable people at the expense of a man they have decided cannot answer back, and I have learned to hate it. The soldier did not react. He did not flush, did not stiffen, did not so much as move his eyes. He simply inclined his head a half-inch, as though the insult had been a request to close a window, and remained standing. Justice Voss was, I should tell you, a genuinely learned man. That is what made the morning so strange. He was not a fool who mistook cruelty for wit. He had written commentaries that were cited in the lecture halls. He had sat on the bench for 30 years. There were barristers with gray in their beards who still called him sir out of an old reflex of fear. But learning had made him proud, and pride had made him lazy in a particular way, lazy about people. He had decided, long ago, that the world sorted itself into those who understood the law and those who existed to be governed by it, and he could tell which was which at a glance. A soldier in a costume, standing behind a country widow, belonged in the second category as surely as the bench belonged in the first. He had no more expectation of legal sense from that red tunic than from the coat rack. "Mistress Ansley," Voss said, turning to the widow with the exaggerated patience of a man performing his own kindness, "your counsel is absent and you are, I am told, unrepresented today. I will not have it said that this court denied a widow her hearing, so I will hear you. But I warn you this is a court of law, not a country fair, and I will not indulge sentiment. You lost below because you had no title to the strip. If you cannot show me a better one this morning, you will lose again, and that will be the end of it. Do you understand?" The old woman opened her mouth, and I saw her lose it. I saw the words she had rehearsed at her kitchen table go to dust the moment the great room and the great voice came down on her. Her hands tightened. Her chin, so brave a moment before, began to tremble. "My lord," she said, "the strip has been ours since my grandfather's day. He fenced it. He grazed it. My husband grazed it. We paid the levy on it, the pasture due, every year to the parish." "Paying a due is not the same as holding title," said Voss. "Any trespasser may pay a due if it eases his conscience. Where is your deed?" "The deed," she faltered. "There was a fire, my lord, at the mill office, years ago, and the parish papers." "So you have no deed." Voss said it flatly, and made a small note, and I understood that in his mind the case was already over. "You have a fence your grandfather built, and a story about a fire. Mr. Devereux holds the registered title to the whole of the lower meadow, which by its plain boundary includes your strip. I have read the papers. Unless you can show me a legal reason why the registered boundary does not mean what it says, I am bound to enter judgment for the appellant." "That is the law, madam. It is not cruelty, it is the law." And here the soldier moved. He did not step forward. He simply spoke from where he stood in the same low, even voice. "My lord, if the court will permit, the registered boundary does not mean what it says. Not in this parish. Not for this strip." The room went still. Not the theatrical stillness of a held breath, the real stillness of 40 people who have just watched something happen that the rules said could not happen. A coat rack had spoken, and it had spoken in the language of the bench. Justice Voss set down his pen very slowly. "I beg your pardon," he said. "I said the registered boundary does not govern this strip, my lord. With respect." "With respect." Voss repeated the two words as though examining them for damage. "Soldier, I do not know your name and I do not much care to. You will be silent. You are not counsel. You are not a party. You are a decoration this good woman brought for comfort, and comfort is the extent of your standing in this room. If you speak again, I will have you removed for contempt, medals and all. Do I make myself clear?" "Perfectly clear, my lord," said the soldier. And then, because he was either the calmest man I have ever seen or the boldest, he added, "But I would remind the court that the right of audience of a McKenna litigant's friend, a person permitted to assist an unrepresented party, is not a matter of the court's indulgence, but of the party's own right, established in furs against the crown and never overturned. Mistress Ansley may ask me to speak on the points of law she cannot argue herself. I am asking the court's leave on her behalf. If the court refuses, the refusal is appealable. I only note it for the record your clerk is keeping." I stopped writing. I want to be honest about what I felt in that instant, because it is the hinge of the whole day. I felt the floor of my expectations tilt. Furs against the crown is not a case a soldier knows. It is not a case most barristers can name off the cuff. It is an old, narrow, half-forgotten authority about the right of a friend to assist a litigant in person. The kind of thing you find in the third volume of a treatise nobody reads for pleasure, cited in a footnote, argued perhaps twice in a generation. And this man in a parade costume had produced it whole, with the correct name of the correct rule attached, and had used it not to make a speech, but to do a very specific legal thing. To convert his own presence from a courtesy the judge could withdraw into a right the judge would have to overrule, on the record, at his own peril. Justice Voss had not sat on the bench for 30 years, without knowing exactly what had just been done to him. I watched him recalculate. It happened behind his eyes, quick and cold. The easy contempt drained out of his face and something more careful took its place, not respect, not yet, but the wariness of a man who has reached for a stick in the dark and touched fur. He was too proud to show it as fear. He showed it as anger. "You have a glib tongue for a fence post," he said. "Very well. I will not give a higher court the pleasure of correcting me on a point of audience. You may speak for the lady on the law and only on the law, but I promise you this, soldier. The moment you stray from the law into theatrics, the moment you cannot back a word you say, I will have you out of that door, and I will make certain the whole city knows that a palace guardsman came into the high court and played at being a lawyer and made a fool of himself. Do you still wish to speak?" "I do, my lord," said the soldier. "Thank you." He set his bearskin on the empty chair beside his aunt with great care. As though it were a living thing, he did not wish to wake. He drew the white gloves from under his arm and laid them across the top of it. Then he straightened, and for the first time he turned his head and looked at Corwin Devereux, and Devereux, who had been smiling, stopped smiling. I do not know what he saw in the soldier's face. From my desk I saw only the back of the red tunic and the straight line of the collar. But whatever it was, it wiped the mill owner's amusement clean off, and Devereux leaned over to the barrister he had hired, a sleek man named Prentice, who charged by the sneer and whispered something urgent. "My lord," the soldier began, "the appellant says the registered boundary is plain, and that it includes my aunt's strip, and that the absence of a deed is fatal. I will show the court 3 things. First, that the registered boundary is not plain, that it rests on a survey the register itself flags as provisional. Second, that a deed is not the only good root of title, and that my aunt holds a better one than the appellant, which the court below never examined because it was never asked to. And third, that the appellant knows all of this, because the appellant's own grandfather is the man who drew the provisional survey and drew it wrong and knew it." Devereux came half out of his seat. "My lord, this is outrageous." "Sit down, Mr. Devereux," said Voss without turning. His eyes had not left the soldier. "You wanted a grand room. You are in one. Let the man make his 3 points, and then I will decide whether he has wasted my morning or yours." He folded his hands. "Proceed, soldier. And God help you if the 2nd volume of the register does not say what you have just told me it says, because I keep a copy behind this bench, and I will send my clerk for it." "I would be grateful if you did, my lord," said the soldier. "The 2nd volume is exactly where I would have the court begin." Justice Voss looked at me. "Clerk, the register, volume 2, the Aldermere parishes." I rose and went for the book, and my hands, I confess, were not quite steady, because I had understood by then the shape of what was coming, not the detail, but the shape. A man everyone in that room had written off as an ornament was about to teach the High Court of Eldermore its own law, out of the plainest of red tunics, and the only question left was how far he would take it before the judge who had mocked him understood what he had mocked. I found the book. I carried it to the bench, and I sat back down at my desk, and I picked up my pen, and I began to write faster than I have ever written in my life, because I did not want to miss one word of it. "This is that record." The soldier waited until the great register lay open on the bench before Justice Voss. Then he asked very simply, "My lord, would the court turn to the schedule of the lower Aldermere meadows? I believe it is the 4th folio, marked with the parish seal, and read aloud the note the surveyor has entered in the margin. Voss did not turn the pages himself. A judge of his station does not thumb a book like a schoolboy. He nodded at me, and I came and found the folio and set my finger under the margin note. He read it silently first, and I watched the corner of his mouth. Then he read it aloud, because a thing read into a courtroom becomes part of it forever, and he was, whatever else he was, a scrupulous man. Boundary of the lower meadow as here drawn is provisional only, pending the resurvey of the fence strip on the north, the title to which is disputed and reserved. Voss let the last words fall one at a time. Provisional, pending resurvey, reserved. He looked up. You knew this note was here? I did, my lord. How? Because I read the register before I came, my lord. My aunt could not afford counsel, so I made myself her counsel's poor substitute, and a man who is going to stand up in the high court reads the papers first. He said it without a scrap of insolence, which somehow made it land harder. The court below entered judgment on the boundary as plain. The boundary is not plain. The register itself, in the surveyor's own hand, reserves the very strip in dispute and calls the whole line provisional. A provisional boundary is not a determined boundary. It cannot be the ground of a final judgment against my aunt, because it does not, by its own terms, decide the thing it is being used to decide. Prentice, Deverell's sleek barrister, rose smoothly. He had recovered his footing and meant to show that the professionals could still put the amateur in his place. My lord, with respect to the gentleman in uniform, a marginal note by a long-dead surveyor is not the operative register entry. The operative entry is the registered title of my client, which is clean and final. A note is a note. It is scholarship. It is not law. It was a good move, delivered well, and half the gallery nodded. The soldier let it sit for a moment. Then he did something I have thought about many times since. He did not raise his voice to answer the sneer. He lowered it so that the room had to lean in to hear him, and in leaning in gave him everything. My learned friend is right that a note is not, by itself, an operative entry, the soldier said. He is wrong that it is only scholarship. Under the Registration Act, Section 19, a provisional or reserved boundary carries a statutory consequence. The register is deemed to give notice of the dispute to every person who takes an interest in the land thereafter. My learned friend's client did not take his interest before the note was entered. He took it after. The date is on his own title. I would ask the court to compare the two. The moment the appellant registered his interest, he registered it with statutory notice that the north strip was reserved and disputed. He cannot now stand before this court and say the boundary was plain. The law will not let a man plead surprise at a thing the register told him to his face on the day he bought. Justice Voss reached for his own copy of the statutes without a word. He found Section 19. He read it, and I saw the exact instant the case turned over in his mind. The instant a proud man understands that the argument in front of him is not clever, which he could have dismissed, but correct, which he could not. Mr. Prentice, Voss said, still reading, is the note dated? Prentice's mouth opened and closed. My lord, I would need to take instructions. It is dated, said the soldier. The 14th of the harvest month, 11 years ago. The appellant's registered interest is dated the following spring. I have both dates. I will hand up the certified extracts if the court wishes, though I believe the court's own volume 2 will confirm them. Hand them up, said Voss. The soldier drew from inside his tunic, not with a flourish, but with the neatness of a man who has folded a paper exactly and knows precisely where it lives, 2 certified extracts, each stamped and sealed. He gave them to me, and I carried them to the bench. Voss compared them to his register. The room was so quiet I could hear the old judge's ring click against the desk as he moved his hand. They agree, Voss said at last. He set them down. He looked at the soldier for a long moment, and the anger was gone from his face now, replaced by something that had not yet decided what it was. You have made your first point, soldier. The boundary is provisional and the appellant took his title with statutory notice of it. I will grant you that. It is well argued. He allowed himself a small, sharp breath. But it is not the whole of the case. A reserved boundary means the strip's title is open. It does not mean it is your aunt's. You have shown me the appellant cannot rely on the plain boundary. You have not yet shown me that Mistress Ansley has any better claim. Open questions are not decided in a widow's favor out of sympathy. So, your second point, you said a deed is not the only good root of title. I did, my lord. May I approach the matter through the lady herself? There is a thing she can tell the court that I cannot, and it is the foundation of everything. Voss inclined his head. The lady may speak, Mistress Ansley. The old woman rose. She was steadier now. I think the sight of her nephew turning the great judge's own book against him had put some iron back in her spine. But her voice still shook when she began, and the soldier did a small kind thing. He moved a half step so that he stood at her shoulder, not in front of her, so that she was speaking to the court and he was simply there, a wall at her back. Tell the court, aunt, he said gently, about the parish beating of the bounds. What you told me, take your time. The beating of the bounds, she said. Every year on the spring feast since before I was born, the parish walks the boundaries of the common and the tithed lands, and the elders name each mark aloud as they pass it, this hedge, that stone, the old oak, the bend of the brook. It is how the parish remembers where things lie when the papers are lost or burned. And every year at our strip the elders name it Ansley's North Pasture, and they have named it so since my grandfather fenced it, 40 years and more. The whole parish has heard it named ours, year upon year, and no man has ever stood up at the beating and said otherwise. Not once. Not the old Deverell, not this one. She lifted her chin at the mill owner. They walked past our fence, and they heard it called ours, and they said nothing because they knew. She sat down, trembling, and the soldier let the silence hold a moment before he lifted his head to the bench. My lord, he said, that is the second root of title, and it is a good one, and it is older than any deed. It is title by immemorial usage, established and acquiesced in, what the older authorities call title by reputation and long enjoyment, evidenced by the perambulation of the parish bounds. The court below never heard it, because the court below was only asked about the deed. But this court sits on appeal to do justice on the whole matter, and I would put it to your lordship that a fence maintained for 40 years, a due paid every year, and a boundary named Ansley's, at the public beating of the bounds for 2 generations, unchallenged by the very family now challenging it, is a root of title that the law recognizes and protects. The appellant's silence at 40 beatings of the bounds is not nothing, my lord. In law it is acquiescence, and acquiescence bars him. Prentice was on his feet again, but he had lost the smoothness. My lord, title by reputation is a doctrine of great antiquity and correspondingly great uncertainty. There is no modern authority that— There is, said the soldier. Halloran against the dean and chapter in this very court, within the memory of men now living. The dean claimed a water meadow on a clean deed. The commoners answered with the perambulation of the bounds and 40 years of unchallenged reputation, and this court held that the reputation, evidenced by the beating of the bounds and acquiesced in by the deed holder, defeated the deed. My lord will find it reported in the 4th series. I can give the page. The principle is not antique curiosity. It is settled law of this jurisdiction, and it has never been overruled. Clerk, said Voss quietly, the 4th series, Halloran and the dean and chapter find it. I went back to the shelves. My heart was going like a drum. And as I ran my finger down the spines I heard, behind me, Corwin Deverell's voice, low and furious, hissing at his barrister. Where did this man come from? Who is he? Find out who he is, and I thought, yes, that is the question, isn't it? That is exactly the question. Who is he? I found Halloran. It was where the soldier said it was, on the page he would have named. I carried it up, and Justice Voss read the headnote, and then he read the ratio, and then he read it a second time, and when he lifted his eyes from the book he was looking at the soldier in the red tunic the way a man looks at a stranger who has just spoken his own secret name. Halloran, Voss said slowly, is exactly the authority you say it is. He closed the book with a soft, heavy sound. I taught it once in the lecture hall 30 years ago to men who are judges now themselves. I had forgotten it. He stopped, and I understood that Justice Voss had come to the very edge of admitting in his own courtroom that a palace guardsman had reminded him of a case he had taught and let slip. He did not go over that edge, but he had gone to it, and everyone in the room had watched him stand there. You have made your second point, soldier. The lady has a root of title and immemorial usage, evidenced by the perambulation that the court below never weighed. I accept it as arguable more than arguable. He drew himself up. But you promised me 3 points, and the third was the boldest of all. You said the appellant knows the boundary is wrong because his own grandfather drew the provisional survey and drew it wrong and knew it. That is not a point of law. That is an accusation. And in my court, an accusation without proof is worse than silence. So I ask you plainly, soldier, and I advise you to think before you answer. Can you prove it? Or was that a soldier's bravado, dressed up in a lawyer's coat? The room held its breath. This was the trap, and everyone felt it. The first 2 points had been argument, brilliant argument, but argument, the kind a clever man might construct from books. The third was a claim of fact against a powerful man, and if the soldier could not make it good, Deverell's money would bury him and the widow both, and Justice Voss, I saw it in his face, half hoped he could not, because a judge does not like to be shown his own forgetfulness twice in one morning by a man he called an ornament. The soldier did not flinch. I have used that phrase all my life without meaning it. That morning I saw the thing itself. He stood in the small pool of the courtroom's attention, and he was as still as he had been when the judge first mocked him, and when he spoke his voice had not risen a hair. I can prove it, my lord. But I would ask the court's patience for one moment, because the proof requires the court to send for a document that is not in this room, and the appellant's counsel will object to my sending for it, and the appellant will not want the court to see it. I ask the court to send for it anyway. Name it, said Voss. The original field book of the provisional survey, not the fair copy entered in the register, the surveyor's own working field book in which he took his measurements in the field before he drew them up clean. Every surveyor keeps one. By the parish ordinance it must be lodged with the parish and preserved. It is lodged. I have seen the receipt. The field book of this survey was drawn by one Thomas Deverell, the appellant's grandfather, in the year the note was entered, and I say that the field book will show a boundary in the field that does not match the boundary he later drew clean for the register, that he moved the line on paper by some 40 yards to the north into my aunt's strip after he came back from the field. The clean copy says one thing. His own field measurements say another. And a man does not accidentally move a boundary 40 yards onto his neighbor's, grazing between the meadow and his drawing desk. Deverell was on his feet before Prentice could stop him. My lord, I will not sit here and have my grandfather's name, a respected man, dead these 20 years, dragged through the mud by a costumed nobody who has clearly been coached by some grubbing country attorney. There is no field book. It was lost. It was lodged with the parish, said the soldier, and now, for the first time, something entered his voice, not anger, but a kind of terrible mildness, the mildness of a man who has just been handed the very knife he needed. The appellant says the field book was lost. I have here the parish receipt for its lodgment, and I have here the parish register of documents withdrawn, and I would ask the court to read who last withdrew the field book of the Lower Aldermere survey, and when, and whether it was ever returned. He handed up 2 more papers. The room had gone very quiet again. Justice Voss took them. He read the first. He read the second. And then he looked for a long moment at Corwin Deverell, who had gone the color of old ash. The field book of this survey, Voss said in a voice like a slow bell, was withdrawn from the parish 4 months ago by the appellant, Mr. Corwin Deverell, in person, signed for in his own hand, and it was never returned. He set the papers down. Mr. Deverell. Where is the field book? The silence that followed was the loudest thing I have ever heard in a courtroom. Deverell began. I withdrew it to consult it in preparation for this appeal, and it must have been mislaid, my lord, at my house, among my papers. I cannot be expected to. You told this court a moment ago that it was lost, said Voss. You now tell me you withdrew it yourself 4 months ago and mislaid it. Which is it, Mr. Deverell? Was it lost long ago, or did you take it, knowing its contents, and lose it since? Because those are 2 different stories, and one of them is a very serious matter. Prentice was tugging at his client's sleeve, whispering frantically, but the mill owner was past hearing him. He had the look of a man who has walked confidently onto a floor and found it is not there. The soldier let the silence do its work. Then, gently, as if he were sparing the man rather than finishing him, he spoke to the bench. My lord, I do not ask the court to decide today whether the appellant destroyed the field book. I ask the court only to apply the law that governs a party who suppresses a document within his control. The rule is old and it is merciful, and it is exactly fitted to this case. Where a party has, or had, in his possession a document material to the dispute, and fails to produce it, and cannot account for its absence, the court is entitled to presume that the document, if produced, would have told against him. Omnia presumuntur contra spoliatorum, all things are presumed against the destroyer. It is not my invention, it is in every text. I would put it to the court that the appellant withdrew his grandfather's field book 4 months ago, because he had read the note in the register, and feared what the field measurements would show. That he has not produced it, because it shows the boundary in the field 40 yards south of where his grandfather drew it clean, and that the court is entitled, indeed bound, to presume exactly that against him, since he cannot account for a document he signed for in his own hand. He paused. He looked not at Deverell now, but at the widow, his aunt, sitting small and straight in her chair. My aunt has no deed, my lord, because the parish papers burned. But the appellant had the one document that would have settled the matter beyond doubt, his own grandfather's honest measurements, and he made it disappear. The law does not reward that. The law presumes against it. And when you add the presumption against the destroyer to the provisional boundary and the statutory notice, and the 40 years of unchallenged reputation at the beating of the bounds, there is nothing left standing on the appellant's side of the scale, and a great deal on my aunt's. I say the appeal must be dismissed, the strip declared hers, and the matter ended. That is the law, my lord. I have only asked the court to apply it. He stopped. He had been speaking, all told, perhaps a quarter of an hour, and he had never once raised his voice, and he had turned a case that a proud judge had already decided in his own mind completely over on its back. And Justice Voss, I will never forget this, leaned slowly back in his great chair, and looked at the man he had called a decoration, an ornament, a fence post, a palace costume, and said, in a voice from which every scrap of contempt had been scoured away, "Soldier, who in God's name are you?" The soldier did not answer at once, and into that pause before he could, Corwin Deverell found his voice again, because a cornered rich man does not surrender, he attacks, and Deverell had a great deal of money and a great deal of practice at making trouble go away. "My lord," Deverell said, standing, and his voice had turned oily and reasonable, the voice of a man who has decided to change the game. "I withdraw nothing I have said about my grandfather, whose honor I will defend, but I put a question to this court that I think your lordship, as a guardian of proper procedure, cannot ignore. Who is this man? He wears the uniform of the King's Guard. He is not a barrister, he holds no rank at the bar, he has taken no oath as an officer of this court, he is not on the roll. He is a serving soldier of the crown, standing in a court of law, arguing law in uniform on behalf of a private litigant against another subject of the king. My lord, is that even permitted? Is it not, in fact, a grave irregularity, a serving guardsman using his position, his uniform, the prestige of the crown itself, to lean on the scales of a private lawsuit? I say his whole intervention is tainted. I say it must be struck out. And I say that if he is what he appears to be, he has no business here at all, and if he is something else, then he has come into this court under false colors, and either way the appeal cannot properly be decided on anything he has said. It was, I must admit, a clever stroke. It changed the subject from the field book, from Devereux's own guilt, to the soldier's standing, and it put its finger on a real thing. The man was in uniform and he was arguing law, and that was, on its face, strange. I saw a flicker of doubt cross even Justice Voss's face. For the whole point of the morning, the judge's contempt had rested on the assumption that the uniform meant the man was only a soldier. Now Devereux was trying to turn the uniform into a weapon the other way. To say that because the man was a soldier, he had no right to be a lawyer, and his brilliance was therefore a kind of trespass. The gallery, which had swung entirely to the soldier's side, wavered. People began to murmur, and I understood that this was the false dawn, the moment where the thing that looked won could still be lost, where a clever man's poison could undo a good man's whole morning. The soldier had won the law. Now Devereux was trying to win the man's right to speak it at all. Justice Voss lifted a hand, and the murmur died. The appellant raises a point I am bound to consider, Voss said, and my heart sank, because the old fairness in him would not let him simply wave it away, even now. It is true that a serving officer of the crown standing in uniform in a private cause is, he searched for the word, unusual. It might be thought to bring an improper weight to bear. Soldier, the appellant asks the question I asked you a moment ago, and now I ask it not out of wonder but as a matter of law. I must know who and what you are before I can weigh a word you have said. You will tell this court your name, your standing, and by what right you stand in that uniform and argue the law of Eldermore. And I warn you, if the answer is that you are a guardsman playing at lawyer, then the appellant, however guilty, may be right that your intervention is irregular, and I may have to set it aside and hear this case afresh with proper counsel, which the widow cannot afford, which means she will very likely lose. So a great deal now turns on your answer. Who are you? The soldier was quiet for a moment. When he spoke, it was not to boast. It was almost with reluctance, the way a private man gives up a private thing. My name is Elias Renmark, my lord. I am a serving soldier of the king's guard, as the court sees. That much the appellant has right. He paused. But before I was a soldier, I was called to the bar of this realm. I read law for 4 years, and I was admitted an advocate of this high court. I practiced for 6 years. I appeared before your lordship twice, though I do not expect your lordship to remember a junior of no importance among the hundreds you have seen. My name is on the roll of advocates to this day. I never struck myself off. A man's admission does not lapse because he changes his coat. If the court sends your clerk to the roll, he will find Elias Renmark, advocate, admitted 11 years ago, still current. I am not a guardsman playing at lawyer, my lord. I am an advocate of this court who happens also to serve his king in a red coat. The uniform is not a costume I borrowed to impress the bench. It is simply what I wear to work. And an advocate of this court does not lose his right of audience because he took the king's shilling. You could have heard a pin fall onto the far end of the gallery. Justice Voss stared at him. You are on the roll of advocates. I am, my lord. Renmark, Renmark, 11 years admitted. Your clerk can confirm it in the time it takes to walk to the shelf. Clerk, said Voss without taking his eyes off the soldier. The roll of advocates. Find the name. I already half knew what I would find, but I went, and I opened the great roll, the bound register of every man and woman admitted to plead before the High Court of Eldermore, and I ran my finger down the entries for the year he had named, and there it was, in the clerk's copperplate of 11 years before. Elias Renmark, admitted advocate, and after it in a later and different hand, a single small annotation, on military service. Not struck off, not lapsed, on military service. His right to stand where he stood had been there the whole time, sleeping in a book, waiting for a widow to need it. "He is on the roll, my lord," I said, and my voice was not entirely steady. "Admitted 11 years past, marked on military service, not struck off. He is an advocate of this court in good standing." The silence in the room changed its quality. It is hard to describe. It went from the silence of doubt to the silence that follows a revelation, the collective intake of breath of a great many people who realize, all at once, that they have spent an entire morning laughing at a man who was, the whole time, better at the very thing they prized than any of them. Devereux sat down as though his strings had been cut. Prentice, the sleek barrister, had the gray look of a professional who has just watched an amateur turn out to be a master, and understood that he had been condescending, in open court, to a colleague of far greater gifts than his own. But it was Justice Voss I watched. Because this was the true crisis of the morning, not the law which was decided, but the man. A lesser judge, humiliated, would have found some technicality to punish the soldier, some way to reclaim his dignity at the widow's expense. I had seen judges do exactly that, and for one moment I did not know which kind of Judge Harlan Voss was going to turn out to be. He had built his whole self on the belief that he could read a man's worth at a glance, and he had just been proven, in front of 40 witnesses, completely and catastrophically wrong. What a man does in the minute after that is the truest thing about him. Justice Voss set down his pen, he folded his hands, and he did the thing I had not dared to hope he would do. "Advocate Renmark," he said, and the change of address from soldier to advocate went through the room like a current. "I owe you an apology, and I am going to make it now in open court on the record your clerk is keeping, because I made my discourtesy in open court, and it is only just that the remedy matched the wrong." He drew a breath. "When you entered this room I called you an ornament, a decoration, a fence post, a palace costume. I did it because I saw a uniform, and I decided I already knew everything worth knowing about the man inside it. That is a thing I have warned young advocates against for 30 years, judging the argument by the coat of the man who brings it, and I did it myself, this morning from that bench, out of pride and out of laziness, and I was wrong. I was wrong about you in every particular. You have argued this cause better than any counsel who has stood before me this season. You reminded me of Halloran, which I taught and forgot. You read the register I keep behind my own bench more carefully than I did, and you did it in a coat I mocked. I am ashamed of the mockery, and I withdraw it, every word, and I ask your pardon. I have clerked in that court for 11 years, and I had never heard a judge say the words "I was wrong" from the bench, let alone "I ask your pardon." I have not heard them since. Advocate Renmark inclined his head, the same half-inch he had given the insult, now given the apology, so that a stranger watching might not have known which was which, and I think that was the point. "There is nothing to pardon, my lord," he said. "The court judged as courts sometimes do, and then the court corrected itself, which is more than most men manage in a lifetime. I would rather stand before a judge who can say he was wrong than before one who never is. Shall we finish the case? My aunt is tired, and she has been robbed for 11 years, and she would like to go home to a pasture that is hers." Justice Voss almost smiled. "Yes," he said, "let us finish the case, but I am not finished with the appellant." And he turned, and the warmth went out of his voice like a door closing, and he fixed Corwin Devereux with a look that made the mill owner shrink in his fine coat. "Mr. Devereux, you came into my court to take a widow's grazing on the strength of a boundary you knew your own grandfather had falsified, and when the one honest document stood in your way, you withdrew it and made it vanish, and then you stood in this room and lied to me about it twice. And finally, you tried to save yourself by attacking the standing of the one man in the room who had actually read the law. I have some things to say to you. But first, Advocate Renmark, finish." Tell me what orders you ask of this court, so that I may make them, and then I will deal with the appellant. But the case was not, it turned out, quite so easily finished, and here is where the mourning became something larger than a boundary and a widow. Because Corwin Deverell had one more card, and it was the card such men always keep for last, and it very nearly won. Prentice rose, recovered now, cold and careful, a professional who has abandoned the merits and gone to procedure, the last refuge of a losing cause. My lord, before your lordship makes any order, I must be heard on a matter that goes to the whole appeal. Everything Advocate Renmark has argued rests on documents, the register note, the certified extracts, the parish receipts, the roll. My client says, and I am instructed to say formally, that these documents are not properly proved. They have been handed up from Advocate Renmark's own tunic. They have not been produced by the parish clerk under oath. They have not been examined and admitted in the regular way. A finding against my client on such grave matters, the falsification of a survey, the suppression of a field book, cannot rest on papers a man simply pulled from his coat, however impressive his coat has turned out to be. I ask that the appeal be adjourned a matter of months for the documents to be proved formally, by subpoena of the parish, by sworn production, by the whole proper machinery of proof. Justice, my lord, must not only be done but be seen to be done in the regular way. My client is entitled to no less. It was, I saw with a sinking heart, a genuinely good point, and worse, a genuinely fair-sounding one. And it was deadly, because an adjournment of months was exactly what Deverell wanted. Months in which the widow's small store of courage might fail. Months in which documents in the parish chest might, like the field book, quietly go missing. Months of expense the old woman could not bear and the mill owner would not feel. Prentice was not asking the court to rule against the widow. He was asking the court to delay, and delay, for a rich man against a poor one, is another word for victory. Justice Voss's brows drew together. Mr. Prentice raises a real point, Advocate Renmark. The documents you have handed up are compelling, but they have come from your own hand, not from formal proof. A court cannot make findings of fraud against a man on the strength of unproved papers. If I must adjourn to have them proved, I must. Tell me why I need not. And now Elias Renmark did the thing that told me, more than all the law before it, what kind of advocate, what kind of man he truly was. He did not argue that the point was unfair, though it was. He did not appeal to the widow's frailty, though he could have. He answered the procedural objection with better procedure, which is the only answer a court can respect. My lord is right that findings of fraud require proof, and my learned friend is right that my papers, standing alone, are only my papers, Renmark said. I would not ask the court to make any finding on my say-so, but I do not need to. I anticipated exactly this objection when I prepared, because it is the objection any competent counsel would make, and my learned friend is competent. A small courtesy to Prentice, who had the grace to look uncomfortable. The parish clerk of the Lower Aldermere is in this building, my lord. He is sitting in the public gallery. I asked him to come, on his own oath and at his own parish's request, and to bring the parish chest with him, because a parish clerk may lawfully produce and prove his own records under oath on the spot. The register note, the receipts, the record of withdrawal, every document I handed up, he can produce an original from the chest and swear to this morning in this room. There is no need to adjourn for months to prove what can be proved in 10 minutes. The proof is present, it only needs to be called. He turned and lifted a hand toward the back of the gallery, and a stout, nervous, entirely ordinary man in a parish clerk's dark coat rose from among the spectators, clutching an iron-bound box against his chest, and I realized that Renmark had planned this from the first word, had known Deverell would run to procedure when the merits failed, and had quietly closed that road before anyone else knew it was open. With the court's leave, Renmark said mildly, the parish clerk will be sworn and my learned friend may cross-examine him to his heart's content on every document, here and now. If any paper I handed up is false, let it be shown false this morning. If they are true, let them be proved true this morning. Either way, there is no ground to adjourn. Justice can be done and seen to be done today. My aunt need not come back." Prentice had no answer, and he knew it, and to his credit he did not pretend otherwise. He sat. "Swear the parish clerk," said Justice Voss, and there was something in his voice now that was almost enjoyment. The enjoyment of an old craftsman watching a young one work at a level he had forgotten was possible. While I administered the oath to the trembling clerk, and while he opened the iron box and produced, one by one, the originals of every document, the register in the parish's own copy, the surveyor's receipt, the record of withdrawal with Deverell's signature raw and undeniable in the parish's own book, the courtroom had a little space of quiet, and it was in that space that Justice Voss did a thing that surprised me. He leaned down toward me at my desk and spoke low under the noise of the clerk's fumbling. "Renmark," he murmured, "Elias Renmark, I do remember him now, a junior, 11 years ago. Brilliant, everyone said so, the sort of young advocate who comes along once in a decade, and then he simply vanished, left the bar at the height of it, no one knew why. There was talk he had lost his nerve or his money or his mind. Voss's eyes had not left the man in the red tunic, and he went into the guard. A brilliant young advocate put down his wig and picked up a rifle and stood at a gate. Why would a man do that? Do you know, clerk? Because I confess I do not, and it is going to trouble me." I did not know, but I found out before the morning was done, because Justice Voss, being now the kind of man who wanted to understand rather than the kind who assumed he already did, asked him. Not on the record, but he asked. The cross-examination, when Prentice attempted it, was brief and hopeless. He tried, gamely, to shake the parish clerk on the withdrawal record. Was it possible the signature was mistaken? Was it possible another man of the same name had signed? Was it possible the field book had been returned and simply mis-shelved? But the clerk, once he stopped trembling, was immovable on the one thing that mattered. The withdrawal book was the parish's own, kept in the parish's own hand, and it said in plain ink that Corwin Deverell of the Mills had taken the field book of the Lower Aldermere survey 4 months since and had signed for it and had never brought it back, and no other man of that name existed in the parish, and the field book had never been returned, because if it had there would be a return entry, and there was none. Every question Prentice asked only nailed the fact down harder. At last he sat and did not rise again, and the thing was proved, not on Renmark's say-so, but out of the parish's own iron box, on the clerk's own oath, in the regular way, exactly as Deverell had demanded and exactly to Deverell's ruin. Justice Voss let the proof settle, then he addressed the room. "The documents are proved," he said. "I make these findings. The registered boundary of the Lower Aldermere meadow is provisional, and reserved as to the north strip by the register's own terms, and the appellant took his title with statutory notice of that reservation. Mistress Ansley holds a root of title in immemorial usage, evidenced by 40 years of unchallenged perambulation naming the strip as hers, acquiesced in by the appellant's own family, which the law recognizes under Halloran. And the appellant, having withdrawn from the parish the one document that would have determined the true boundary, his grandfather's field book, and having failed to produce it and lied to this court about its whereabouts, must have the presumption against a suppressor applied against him. I presume, and I so find that the field book, if produced, would have shown the true field boundary 40 yards south of the line drawn clean in the register, within Mistress Ansley's fence, as Advocate Renmark contended. On all 3 grounds, and on each of them independently, the appeal fails." He turned a page. "I dismiss the appeal. I declare the north strip the property of Mistress Ansley and her heirs, held by title of immemorial usage, and I direct that the register be corrected to name it hers and to strike the provisional line. I award her the costs of the appeal and of the court below to be paid by the appellant. And I reserve, Mr. Deverell, look at me, I reserve the question of what is to be done about a man who withdrew and suppressed a parish document and lied to a court of law about it, twice, under my eye. That is not a matter of costs. That is a matter of the criminal law, and I will be referring the papers and this record to those whose business it is. You wanted a grand room, Mr. Devereux. You have made it the room in which you ruined yourself, and you did it with your own hand, and you cannot blame the widow or her nephew or your grandfather or me. You did it. Now get out of my sight while I decide how much further this goes. Devereux left. I will not describe how a man walks when he has come into a room to take everything and leaves it having lost everything, because you have seen it, or you will. Prentice went after him, carrying his ruined brief, and I did not envy either of them the carriage ride home. And then the room was, for a moment, only Justice Voss, the widow, her nephew in the red coat, the parish clerk repacking his iron box with shaking relief, and me. And the old woman rose from her chair, and she did not go to the judge, and she did not weep, though her eyes were bright. She went to her nephew, and she took his gloved hand. He had put the white gloves back on. I noticed, at some point, the small habit of the parade ground reasserting itself now that the work was done. She took his gloved hand in both of hers, and she said, so quietly that I barely caught it, "Your mother would be so proud of you, Elias. My sister. She always said you were the clever one. She never lived to see how clever." And Elias Renmark, who had not flinched at a judge's contempt or a rich man's threats or 40 faces laughing at him, bent his head at that, and for 1 second the discipline slipped, and he was just a man whose mother had not lived to see him grown into the thing she had hoped for. Justice Voss saw it too, and he waited and did not intrude, and when the moment had passed he spoke gently, as one man to another and not as a judge at all. "Advocate Renmark, the court is not sitting. This is off the record. My clerk may put down his pen." I did not put down my pen, but I stopped moving it, which is a clerk's way of pretending. "I have to ask you a thing that has troubled me since your name went up. I remember you now. I remember a young advocate of extraordinary gifts who left the bar at the height of his powers 11 years ago and vanished, and every man wondered why, and no man knew. And here you are in a soldier's coat, and you have argued today better than I have heard in years. Why did you leave? Why does a man with that gift lay it down and go stand at a gate? Tell me if you will. You need not, but I would rather understand than wonder." Renmark was quiet for a while. He looked at his aunt, and she nodded, small, as if giving him leave. Then he told it plainly, the way he did everything. "When I was a young advocate, my lord, in my 3rd year at the bar, I was given a case. A boundary case, as it happens, smaller than this one, poorer even than this one. An old man, a tenant, against a landlord who wanted his cottage. The old man had lived in it 40 years and had a right to it, and I knew it, and I could have proved it if I had done the work. But I was young, and I was busy, and I was in love with my own cleverness, and I did not do the work. I did not read the parish papers. I did not find the record that would have saved him. It existed. I found it later, too late, and it would have won, because I was arguing 3 cases that week and his was the smallest, and I thought I could carry it on my wits without the labor. I lost it on my wits, and the old man lost his cottage at 70 years of age because his advocate was too proud to read the papers. He paused. He died that winter. Turned out of the only home he had known in the cold because I was clever and lazy, which are the 2 things, my lord, that between them do more harm in a court of law than all the wickedness of men like Devereux. Wickedness at least announces itself. Cleverness that will not do the work wears the robe of virtue while it kills." The room was very still. Justice Voss did not move. "I could not stay after that," Renmark went on. "Not because I had lost a case. Advocates lose cases. Because I understood what I was. I had the gift, and I would not pay for it in labor, and a gift you will not pay for is a danger to everyone who trusts it. So I left. I did not strike myself off. I could not quite bring myself to close the door forever, but I put down the wig and I went into the guard, because the guard is the one trade in the world that will not let a man be clever and lazy. You stand your post. You do the small thing exactly right, every hour, whether anyone is watching or not, whether it is interesting or not, because the whole meaning of the thing is in the doing of it correctly. 11 years I have stood my post. 11 years I have learned to do the unglamorous thing perfectly and to want no credit for it. And somewhere in those 11 years, the laziness burned out of me, my lord, and only the gift was left, and the discipline to feed it. He looked down at his aunt's hand, still in his. So when my aunt's letter came and I read that she was to lose her pasture to a rich man because she had no counsel and no deed, I did not send money. I read the papers, every one of them. For 3 weeks off duty by candle, I read every paper in that parish chest because I had learned at the cost of an old man's life that the papers are where justice lives and that no cleverness excuses a man from reading them. That is why I won today, my lord, not because I am clever. I was always clever. I won because for 11 years a red coat taught me to do the work. Justice Voss sat with that a long time. When he spoke, his voice had gone rough at the edges, the way an old man's does when he has been reminded of the whole cost of his trade. I have been on this bench 30 years, Advocate Renmark, he said, and I have never heard a better sermon on what our work is, nor a worse indictment of how I began this morning. I mocked a man for his discipline, and it was his discipline, his willingness to do the small, dull work I would not do, that I did not do on this very case, when I read the boundary as plain because reading it plain was easier, that undid me. You did not beat me with cleverness. You beat me with labor. That is a lesson I thought I had finished learning before you were born, and it turns out I had not, and I am grateful to have learned it again from you, however it stung. He looked down at the widow. And I am glad, more glad than I can say in a courtroom, that this time the old person did not lose the cottage. The old woman looked up at him, startled to be spoken to directly by the great judge who had frightened her so at the start of the morning, and Justice Voss did a last thing that surprised me. He rose from the bench, which a judge does not do for a country widow, and he inclined his head to her, a bow, small but real, from the highest man in the room to the lowest. Mistress Ansley, he said, the court owes you an apology as well. I told you when you came in that this was a court of law and not a country fair, and that I would not indulge sentiment. I said it to warn you not to hope. It was unkind, and it was also wrong because the law, done properly, was on your side the whole time, and it was I who had not looked closely enough to see it. The strip is yours. It has been yours for 40 years, and now the register will say so, and no man will take it from you again. Go home to your pasture, madam, with the court's respect. I have set down a great many things said in that room over 11 years, and I do not think I have ever set down anything I was prouder to write than that. There is more to tell, because the morning had consequences that ran on for months, and you should have them, so that you know the reckoning was real and not merely a fine speech that faded when the doors closed. The papers Justice Voss referred, the record of the withdrawal, the parish clerk's sworn evidence, the whole account of the vanished field book, went where such papers go, and in the fullness of time Corwin de Verl answered for them. Not for the boundary. The boundary was settled and beyond appeal. He answered for the field book, for taking a public document that stood in his way and making it disappear, and for lying about it twice to the face of a court. Men had thought de Verl untouchable, because his money reached into a great many pockets, and his mills employed a great many families, and it was easier all round to let him have his way. But a court record is a stubborn thing, and Justice Voss was a stubborn man once his mind was set, and he did not let it fade. De Verl was tried, in that same building before a different judge, and he was convicted of suppressing the document and of his falsehoods to the court. And though he kept his liberty, it was not that kind of crime. He did not keep his standing. A man who has been shown, in open court and open record, to have tried to rob a widow by hiding his own grandfather's honest measurements is a man whose word is worth nothing thereafter. And in the world de Verl had ruled, a word worth nothing is ruin. The great men who had dined with him found reasons to dine elsewhere. The magistracy he had expected to be appointed to went to another. His mills he kept, but the fear that had oiled them was gone. Men who had jumped when he frowned discovered that his frown had lost its teeth, and treated with him as with any other man, which for Corwin de Verle was its own kind of poverty. He had come into the high court to take one small strip of grass from an old woman, and he had walked out having lost the one thing his whole life was built on, which was the belief of other men that he could not be beaten. Elias Renmark beat him, quietly in a morning, with a red coat on and the truth in his hand, and the truth did the rest at its own slow pace, as it does. The field book itself was never found. I do not think there is much doubt about what became of it. But it did not matter in the end, because the presumption against the man who suppresses a document had done its work, and the truth the field book would have told was written into the judgment as surely as if the book itself lay open on the bench. That is the beauty of the rule Renmark invoked, omnia presumuntur contra spoliatorum, all things presumed against the destroyer. A wicked man may burn the evidence of his wickedness, but the law is not so easily blinded. It treats the ashes as proof of exactly the thing he burned them to hide. Destroy the honest measurement, and the law will assume the measurement was honest and against you. There is a deep justice in that, and Renmark had reached for it at exactly the right moment, the way a swordsman reaches for the one guard that answers the one blow. But the part of the aftermath that spread furthest and that I want most to set down is what became of the man himself, because a thing like that morning does not stay inside a courtroom. Clerks talk. Barristers talk. The parish clerk, once he had recovered from his fright, told the story in every inn between the Aldermere and the city, growing it a little each time, until half the realm had heard of the king's guardsman who walked into the high court in his parade coat and outlawyered the whole bar to save his aunt's pasture. Most of the tale as it traveled was nonsense. I heard a version in which Renmark had drawn his rifle on the judge, which is exactly the opposite of everything that happened. But the bones of it were true, and the bones were what caught people, because everyone has been mocked for what they seem to be by someone who could not be bothered to learn what they are, and everyone likes to see that particular arrogance broken. It reached the palace, of course. It could not fail to. A serving man of the king's guard had made himself, for one morning, the most talked-of advocate in the realm, and the guard is not a body that overlooks the doings of its own. I was told, I cannot swear to it, but I was told by a man who had it from a man who was there, that when the account reached King Alaric himself, the king listened to the whole of it in silence, and at the end asked only one question. Did the man leave his post to do it, or did he do it on his own leave in his own time? And when he was assured that Renmark had done the whole thing off duty, on his lawful leave, having asked nothing of the guard and used nothing of the crown but the coat on his back which was his to wear, the king is said to have been quiet a while, and then to have said, "Then he did it as a man, not as a soldier, and that is better. A soldier who is only a soldier is a fine thing. A man who is a soldier because he chooses discipline, and who carries that discipline into every other part of his life, into a courtroom, into the defense of an old woman with no one else, that is what the coat is supposed to mean. See that he is not punished for it, and see that he knows I know." Whether the king said those exact words, I will not pretend to certainty. But something like them must have been said, because Renmark was not disciplined for the business. Some narrow-minded officers had muttered that a guardsman had no place making a spectacle of himself in a civil court, uniform and all, and there was a moment when it might have gone against him. And instead of a reprimand he received, quietly, without ceremony, a word of the king's approval passed down through his colonel, which in that service is worth more than a medal because it cannot be bought or lobbied for. Only earned. And I am told that the crown prince, Rowan, who was then a young man beginning to take an interest in the law and the courts as heirs must, asked to have the whole record of the case sent to him, and read it, and afterwards sought Renmark out to talk with him about it. The boundary, the presumption against the destroyer, the beating of the bounds, all of it, so that a soldier at a gate became, for a season, an unofficial tutor to the heir of the realm in the parts of the law that the tutors with wigs had made dull, and he had made alive. Princess Adela, the king's sister, who had a soft spot for anyone the powerful had underestimated, is said to have declared at a supper that she would sooner have Renmark argue her case than any silk in the kingdom, uniform or no, and to have meant it. I tell you all this not to gild the man, he would have hated the gilding. He was, to the end, a person who wanted the work to speak and himself to be quiet, but because it matters that the world did not simply forget. Too often the man who does the right thing quietly is quietly forgotten, and the loud men keep the field. This time it went otherwise. This time the discipline was seen, and named and honored up to the very top of the realm, and a guardsman learned that the small, dull, perfect work he did at his post, unwatched, was the same substance as the work that had beaten a rich man in the high court, and that the king himself understood it to be so. As for Renmark, he went back to his post. That is the part I find I return to most of all of it. He did not resign from the guard to take up the law again, though every door was now open to him. He could have had a full practice within a month, briefs pressed on him by the same men who had never heard his name. He did not do it. He went back and stood his gate. When I asked him about it some months later, I had gone out of my way to find him, because the morning had changed how I saw my own small work, and I wanted to tell him so. I found him at his post outside a palace forecourt, immaculate, motionless, eyes forward, exactly the ornament the judge had first taken him for, and I had to wait until he was relieved to speak with him at all, because he would not so much as turn his head while he was on duty. When at last he was off and had put off the bearskin and we walked a little in the cool of the evening, I asked him why. Why go back to the gate when he could have the courts? He thought about it in his careful way. Because the gate is where I learned to deserve the courts, he said. If I left the guard, I would within a year be back to what I was at 26, clever, sought after, busy and cutting corners because I could get away with it. The discipline is not a stage I passed through. It is the thing itself. I stand my post so that when a widow needs me, I am the kind of man who reads all the papers. Take away the post, and in time you take away the man who reads the papers, and you are left only with the clever one, and I have already seen what the clever one does to an old man in the cold. He looked out at the lit windows of the palace. I will help my aunt, and I will help the next one, and the one after whenever the need comes to me, and I will do it as well as any advocate in the realm, better than most. But I will do it from the gate. The gate is what makes the rest of it true. I have thought about that many times in the years since. I think he was right, though I am not sure I could live it. Most of us cannot hold both things, the gift and the discipline, the fire and the patience. We let one eat the other. Renmark held them both, and the way he held them was to keep standing his post, doing the small, unwatched thing perfectly, so that the great watched thing, when it came, would be built on truth all the way down. The courtroom was the once-in-11 years blaze. The gate was every ordinary morning that made the blaze possible. Justice Voss, I should tell you, was changed by it too, and that is the last thing worth setting down because it is the part that touched the most lives in the end. He was an old man and set in his ways, and I did not expect a single morning to move him far, but it moved him. In the months and years that followed, I watched him become, from the same bench, a different judge in one particular respect. He stopped reading men by their coats. When an unrepresented litigant came before him, a laborer who could not afford counsel, a widow with a story about a fire, a shabby man with a strong case and no way to dress it up, the old contempt did not come. He listened. He made allowances. More than once I saw him lean forward and help a floundering poor man find the legal shape of the true thing he was clumsily trying to say, the way a good judge is supposed to, and so few do. And I knew, watching him, that he was seeing Elias Renmark in a red coat every time, and remembering that the plainest exterior in his courtroom had once held the finest legal mind he had met in 30 years, and that he had almost thrown a widow to the wolves because he had assumed otherwise. He never forgot it. He made a rule of never assuming it again. And I do not know how many poor litigants got a fairer hearing in that court in the last years of Harlan Voss's life because of one morning in the cold month. But it was not a small number, and not one of them ever knew the name of the soldier they had to thank. The strip of pasture is still there. I rode out to see it once, years later, on a whim, because I wanted to know that the thing we had all bled over that morning was a real place with real grass, and not merely a line in a register. It is a very ordinary strip of ground, a few acres of good grazing on a gentle north slope, fenced in the old way with a hedge and a ditch, with a bend of the brook at the bottom of it, and an old oak at the top that must be the very one the elders named at the beating of the bounds. There were sheep on it when I came. Mistress Ansley was gone by then, God rest her, but her grandson farmed it, and I did not tell him who I was, only that I had heard the story of how his family nearly lost it and had wanted to see the place. He nodded and looked out over the grass and said, "My grandmother used to say a soldier saved it. Her sister's boy. She never let us forget it. She said he came in his king's coat and stood up in the great court and knew the law better than the judge, and gave us back our fields, and then went back to standing at his gate as if it were nothing." He shook his head, smiling a little. "I always thought she'd got it tangled with a tale. A guardsman knowing the law better than a judge. That's a story, isn't it? That doesn't happen." I looked at the good grass, and the old oak, and the sheep that were alive because a man once read every paper in a parish chest by candlelight when he owed the world nothing and did it anyway. "It happened," I told him. "I was there. Every word of it happened, and it happened exactly the way your grandmother told you, and you should be proud of it all your life." He looked at me a little strangely, and I did not explain, because some things are better left as a family's cherished story than turned into a stranger's testimony. I rode home. And I set down this record, all of it, from the first mocking word the judge spoke to the last, so that it would not depend forever on a parish clerk's growing tale or an old woman's memory, but would stand somewhere in plain ink, the way the true boundary of a thing should always stand, written down, provable, and beyond the reach of any man who would move the line in the dark. I have clerked in the High Court of Eldermore for 11 years. I have seen a great deal of the law and a great deal of men, and most of it fades. But I have never forgotten, and I never will, the morning a soldier everyone had written off as an ornament walked into that room, and stood quietly behind an old woman's chair, and taught the proudest judge in the realm. And I think, all of us who watched, that you cannot read a man's worth off his coat, and that the ones we are quickest to mock are so often the ones who have paid, in some quiet, unwatched way, the highest price of all to become what they are. He knew the law better than anyone in that room. He knew it because he had done the work no one saw, and that, in the end, is the only way any of us ever comes to know anything worth knowing at all.